So I now want to turn briefly to the Secretary of State's emails from the Arizona Secretary of State's office that are directly involved in this particular aspect of social media censorship. These are, as I understand, I received them from staff. I understand they're released pursuant to an open records request. I reviewed those emails, and I find an astonishing series of takeaways. First of all, it's clear that those emails are examples of the very federal national security censorship consortium that was set up in 2020. There's a direct participation of Arizona state officials in that. And as I went through those emails, I thought I had a number of key takeaways. First of all, you see emails from 2020, 2021, and 2022. So it's a years-long process. It's not the sort of thing that shows sign of flagging anytime soon. Once state officials kind of get a hold of the power to silence speech on social media they don't like, they're unlikely to relinquish it voluntarily. Secondly, you see a series of emails where they're emailing reports of misinformation directly to the platforms, but also they're emailing them to the very alphabet soup of agencies that I talked about earlier, the EISAC, which is a clearinghouse funded by the federal national security state to ensure that there can be, that gives the backing of the federal national security state to these reports of disinformation from state and local officials. So you see multiple emails where the Arizona Secretary of State's office is participating in this very federal censorship apparatus that was set up at the point of a federal bayonet. Thirdly, if you look at those emails, you see the highest levels of the Secretary of State's office are involved. It isn't sort of career staffers who decided to do this on their own. Almost all the reports come from the communications director, who's a very senior sensitive officer within the Secretary of State's office, and some of them come from the Secretary of State herself. Fourthly, what's being flagged in those emails is absolutely core political speech, including core political speech of your direct political opponents. There's multiple emails or tweets or social media posts by the Arizona Republican Party are flagged by the Secretary of State's office to the platform saying, please take down off of social media what the Arizona Republican Party has stated. There's another where a state senator-elect had published a long series of posts, I believe on Facebook, about election integrity and election concerns, and the request from the Secretary of State's office is not, we disagree with this, here's our counter speech, it is take that down so nobody can read it. So there's an attempt to silence political opponents that goes on here. Fifthly, what you see is repeated emails from the Secretary of State's office is not just saying take down this post or that post that's expressing disinformation, but what they say the platforms is we're flagging an entire account. We want a social media account examined. They want to silence not just acts of speech, but the speakers themselves. These disfavored speakers, we don't want them to be able to talk at all on social media. Sixthly, you see situations where the Arizona Secretary of State's office is engaged in its own bit of misinformation when it's doing the flagging. It's mischaracterizing the posts that it's trying to get taken down from social media in its emails to the platforms and to the federal consortium and saying, for example, there's an email chain where somebody was trying to lobby the Secretary of State's office about the eligibility of Kamala Harris to be on the ballot in 2020. And the Secretary of State's office says, take this down because it falsely implies that Secretary Hobbs supports this. Well, if you read that email, there's nothing in it that suggests that Secretary Hobbs supported it. It was just a mischaracterization. That there was an engagement in their own misinformation when they were flagging them. And that one, in fact, the platform saw through it and they said, no, we don't see any violation of our policies here. And in response to that, there's an internal chain where they say, make derogatory comments about Facebook and how terrible it is for not taking down the misinformation that we disfavored. Seventhly, you see, just like you see in the election integrity partnership, you see an attempt to throttle entire narratives, not just individual acts of speech, but overarching umbrellas of speech, entire narratives of speech. And again, you see this in the Sharpiegate context. You have a whole series of emails from the Secretary of State's office to Twitter and Facebook saying, is there any way we can engage in systematically shutting down the Sharpiegate narrative? And interestingly enough, what you see is a response from the platform saying, this is being flagged by multiple partners and we're shutting the whole thing down, essentially. And of course, we now know from the Election Integrity Partnership discovery that those other partners who were reporting it were the federally created Election Integrity Partnership Consortium, right? So you had federal officials directly involved in that. And we know from the report that some likely Arizona state officials directly involved in sort of debunking that and convincing the platforms to take that down. And then, in addition to that, because these reports of disinformation are going through the EI-ISAC, so you see multiple emails to the EI-ISAC. You even see emails where there's references to CISA, where EI-ISAC responds and says, thank you for sending this. We have forwarded to CISA, which is a federal national security agency, for them to pass on to the platforms to have that taken down. The EI-ISAC, and you have them having reports of misinformation going directly to the Center for Internet Security. That's CIS. It's misinformation at cisecurity.org. That's the Center for Internet Security, which again runs the EI-ISAC, which is funded by CISA. So you have state and local officials trying to employ the coercive power of the federal national security state and the federal law enforcement state to get the power of that behind their request for censorship. And there's a fascinating email between the Secretary of State's office, the Arizona Secretary of State's office, and the head of NAS, the National Association of Secretaries of State, where the head of NAS says, oh, you're flagging, I think it's in November, December of 2020, oh, you're trying to flag some misinformation to the platforms by emailing twitter.gov directly? Don't do that. That's not going to get you to the front of the queue. I'm characterizing it. Go through the Center for Internet Security. And sure enough, from then on, they start routing reports of disinformation through the Center for Internet Security, which of course runs the EI-ISAC, which has the backing of the national security state. So in effect, that basically have state and local officials working hand in glove with federal officials and academic researchers. And behind it all, there's a conscious intent to have the federal coercive power of the federal law enforcement and national security state behind these requests to remove disfavored content from social media. So I want to conclude my comments now by making some maybe very modest recommendations for legislative consideration. I believe, and my comments should make clear, that it's deeply problematic under the First Amendment and under the free expression provisions of every state constitution, including that of Louisiana's, very, very problematic for state officials to be involved in any way, form, flagging misinformation to social media platforms, trying to convince social media platforms to take down speech that they don't like. That's a big problem under the First Amendment. There may be circumstances where it's okay, although they ought to be very, very narrow. State and federal officials should not be in the business of demanding that booksellers burn books that express disfavored political viewpoints. They should not be in the business of demanding that newspapers stop running editorials that criticize the government. And they should not be in the business of demanding that social media platforms take down speech by ordinary Americans that contradicts the viewpoints and narratives that they prefer. And so a state legislature like the Arizona State Legislature could consider modest legislation to prohibit that act of flagging by social media platforms. And any such legislation ought to have two aspects to it. It ought to very clearly express the content that is illegal under state law, illegal under state statute, that would be done in one's official capacity as a state, as any kind of state official or employee to try and get somebody else silenced, an ordinary American, silenced on a social media platform. And there should be clear and robust consequences for violation of that. So the U.S. Supreme Court, I quoted earlier in Norwood against Harrison, says it is unconstitutional for a government official to induce, promote, or encourage a private organization to do what is constitutionally forbidden to do itself. So one could start with that language as possible language to prohibit state officials from engaging in this flagging operation. And then there ought to be real teeth to such a prohibition. The kinds of teeth that one could consider would be I have two ideas which are drawn from state consumer protection statutes and state anti-discrimination statutes. With respect to state anti-discrimination statutes, many of them have fee-shifting provisions. So you could give a private individual who's injured in a form of censorship a form of liquidated damages. For every post that got censored, you get X as an award, and fee shifting. If you get an attorney and you sue a state official, maybe you get $5,000 per violation plus your fees. That fee shifting provision gives lawyers the economic incentive to actually litigate these issues. Because what you see, recognized by the Supreme Court's opinions again and again, is First Amendment interests are fragile. And it's very seldom that there's the economic incentive to bring a major federal or state lawsuit to try and vindicate the fact that you had one post taken out from Twitter. And actually, in this day and age, a lot of times you don't know you're being censored, because a very large proportion of it happens through what's called shadow banning, where you suspect, your friends are saying, hey, I haven't heard from you on Twitter for a while. And you're like, what do you mean? I've been posting every day. Oh, I haven't been seeing it. That happens all the time, right? So there should be a clear prohibition, and there should be clear consequences to it. And a state legislature from the consumer protection area could consider an analogy where there's dual enforcement. So if you're a victim of social media censorship at the instigation of a state or local official, you could sue the official who violated your rights, get some sort of civil penalty or liquidated damage, plus a fee-shifting provision. But in addition, you could award enforcement authority to the state attorney general's office to go after the platforms directly. That's what you see in the consumer protection area in almost every state that I'm aware of, is you have dual enforcement. You have an attorney general who can enforce it, and you can be the same prohibitions can be enforced by private lawsuits. And private lawsuits that give sufficient potential consequences to actually deter this. Because without real deterrence, this problem will not go away. I think the message, one of the clearest takeaways from the Missouri against Biden evidence is that censorship, once people get a hold of that power, they want more and more and more of it. And a stop should be put to it, and there's very important work to be done by state legislatures, including the state legislature of Arizona. So with that, I thank the panel for their time today. I thank you, and I invite the panel I'm happy to respond to any questions that anyone may have.